Welcome to the December 15th, 2020 Planning Commission meeting. I'd like to call this meeting to order. My name is Chris Ramey and I'm chair of the Eugene Planning Commission. Thank you for joining us in this remote meeting format we're using in response to Governor Brown's Stay Home, Save Lives order. This format enables the Planning Commission to meet, hear from the community, and take care of business while keeping its members, staff, and the public safe. Tonight, we will be holding a public hearing on an appeal of the hearings official's denial of a zone change request for RNS Management LLC, City File Z20-7. Before we begin, this Eugene code also requires that planning commissioners disclose any conflicts of interests, ex-parte contacts, biases, or abstentions. Oh, that's easier than it looked. In a quasi-judicial proceeding like this one, the parties are entitled to an impartial or neutral decision maker. To ensure this fair consideration, the Eugene Code and the Planning Commission's rules attempt to limit ex parte contacts or communications between a party and the decision maker outside of the public hearing process. Each planning commissioner must disclose and describe the substance of any communication they have had about this application outside the public process. The planning commissioners must also disclose any conflicts of interest, that is, whether the decision they are about to make could or would result in a personal financial gain to themselves, their business, or a member of their household. Finally, a planning commissioner cannot participate if he or she is biased. That is, for whatever reason, he or she is incapable of rendering an objective decision on this appeal. I have been made aware that one of our commissioners has a conflict of interest to disclose. I'd like to call on Commissioner Taylor at this time.
Hi, everyone. So the architectural firm, TBG Architects and Planners, where I work, has been retained by RNS Management LLC to act as RNS's representative regarding zone change application Z20-7. The hearing's official decision on the application has been appealed to you, the Planning Commission. Therefore, pursuant to ORS 244.120, Eugene Code sections 2.333 and 9.7065, and the bylaws of the Eugene Planning Commission, I am declaring an actual conflict of interest with respect to the RNS Management LLC zone change application, once again, Z20-7. And I will not participate in any discussion or decisions by the Planning Commission regarding this application. And that is so essentially I will depart from the meeting. I will also not be attending at all. So this same disclosure applies to the meeting on Thursday.
Thank you, Commissioner Taylor. You are.
Thank you.
Do any other commissioners have conflicts of interest or ex parte contacts to disclose? Head shaking, head shaking. Okay. Does anyone in the audience or a member of the commission wish to challenge the impartiality of the planning commissioners? Keep in mind, this is not the time for testimony, only an opportunity to explain a concern about the impartiality of a commissioner that has not been excused at this time. If you have such a concern, please raise your hand using the hand icon or dial *9 and staff will let you into the meeting to explain your concern. Do we have anyone asking to speak?
We do. We have two hands up. We have Sandra Wu and Liam Sherlock.
Okay, let's let them speak.
So my name is Ed Laurie, and I'm actually Sandra Wu's husband attending the meeting tonight. And I spoke yesterday at the Planning Commission about these issues of conflict of interest. And I am still a bit troubled. I understand the rules. I was able to get hold of those rules and regulations from the state and from the city about the planning commission. I understand that this sort of thing is permitted, but I do want to reiterate a point and wonder whether or not the commissioners would like to investigate this point in the future. That this actual conflict of interest is, of course, not just a conflict of interest for the individual person, commissioner who might have it, but the actual conflict of interest is also a conflict for the commissioners. Because if a person has an actual conflict of interest, it's a shadow over the commissioner's objectivity in making a judgment, because they are making a judgment upon one of their colleagues who they have been dealing with on a regular basis for however long, and therefore may have a bias towards that person. Now, I understand that the state has suggested that there's just, an impossibility of avoiding these sorts of things, especially in communities which are small. Myself, I believe that the Eugene community is probably big enough to handle this, but perhaps not. At any rate, the important thing for me is that I did not learn of Ms. Taylor's actual conflict of interest until it dawned on me after a couple of meetings before hearing officials, where she made the case, of course, for the ENS or RNS management company. And then I realized that she was also a commissioner. And I said to myself, my God, how can she do this? How is this possible? So though she made her commitment tonight not to take part in this, I would like to suggest that for future activities, any hearing official or any hearing that was going to possibly reach the commission if somebody had an actual conflict, that they should disclose this at those meetings as well as any meetings that actually take place for the Planning Commission. And the Planning Commission should, I think, insist on this so that everybody in the public understands what the situation is from the start, instead of having these terrible suspicions about the commission. When I realized that Ms. Taylor was a commissioner and nobody had said anything, I said to myself, they must approve this. They have no problem with it. And I presume that you have not approved of it until she makes such a declaration. So her words there earlier, if you will, are ones that are under suspicion, and it puts the commission under suspicion. So I think you ought to make that change in the future and make sure that anyone who has a conflict of interest reveal it on any kind of hearing or any kind of public meeting where the issue may come before the Planning Commission. Thank you.
Thank you, Mr. Lowry.
So now we have Liam Sherlock.
Yeah, thank you, Planning Commissioners. And just a quick follow-up. I mean, I know Kristen Taylor. I know she's a person of great honor, and there's no inherent accusations here impugning that. I just do think that my clients, and I represent the Fairway Loop Neighborhood Association, are concerned about this, and as affected citizens and property owners, they do have a right to expect that, of course, any governmental decisions in a quasi-judicial proceeding like this one will be based on consideration of the facts and the decision criteria, so that there's a fair hearing before an impartial tribunal. So having said that, I just want to make sure that if there are any commissioners who feel like their personal or professional relationship with their fellow commissioner, Ms. Taylor, who is a lead consultant in this application, could color that commissioner's judgment in a way that would make it difficult to separate that relationship from the land use decision at hand, I would just ask that they, make that clear here and now. I mean, we're all human, and so it's not, it's not unexpected if there would be a inherent hesitation, shall we say. But if, so I just want to put that out to all the commissioners, and if there are any considerations or concerns, to hear them, and so that we can proceed with this appeal on the merits.
Thank you, Mr. Sherlock.
So we don't have any other hands raised.
Thank you. Okay, one more chance. Any ex parte contacts, biases from the commission? Seeing none, and having taken care of that, I would like to take a moment to explain who the Planning Commission is and our role. We are unpaid volunteers appointed by the City of Eugene, the City Council, to 4-year terms on the commission. We all live and work in Eugene, like many of you. We directly advise our City Council on all matters related to land use, and we are also tasked with making certain land use decisions on behalf of our City Council. We're responsible for upholding the laws of our city and our state, the policies of our City Council, and of course, at the same time, we're also responsible to everyone that lives and works in Eugene. We're at-large members, which means we have to consider the needs of the community as a whole, as well as the needs of all groups and neighborhoods. We're also human beings, which means that each one of us has a personal view that makes us who we are. But as planning commissioners, we're committed to balancing all of our needs as a community and to making the best decisions we possibly can based on our policies and our laws for us and for our future generations. That can be pretty tough to do, and we know not everyone will agree with every decision we make. So as we proceed today, we want you to know up front that we are listening and that we care deeply about you and about our community. We will listen carefully to your concerns and your hopes. Even if we cannot do what you want, know that you will be heard, and that we will strive to make the best decision possible. Thank you for listening to that. Some of the terms we have to use are legalistic, so I'll try to explain the requirements in plain English the best that I can. Since this is an appeal hearing, there are unique procedures which are legally required to follow, which we are legally required to follow. The decision of the Planning Commission on this appeal is considered quasi-judicial. So we will use a quasi-judicial format for this public hearing. This means we have a certain order of speakers that we need to follow, and there are certain rules or criteria that our decision must be based upon. The purpose of tonight's hearing is to receive relevant testimony on the appeal before us. I want to remind everyone that your testimony must be directed toward the issues identified in the appeal statement and the applicable approval criteria from the Eugene Code. No new evidence can be accepted by the Planning Commission, and we can only accept testimony related to evidence that is already in the record. What this means is that if you are testifying, what this means is that you should be testifying about, one, the materials and information already presented to the hearings official in the public hearing process, and two, whether or not you think the hearings official made a mistake based on the approval criteria for the zone change. I also want to remind everyone that the failure to raise an issue with sufficient specificity to allow the Planning Commission and other parties to respond will preclude future appeals on that issue. In other words, now is your opportunity to raise issues as clearly as you can so that the city and other parties can address them. Those wishing to speak during the public hearing will be asked to virtually raise your hand. I will also ask that individuals other than the applicant limit their testimony to 3 minutes to allow everyone a chance to speak this evening. Because the applicant filed the appeal, they will be allowed a longer time to explain their appeal issues. There are different ways to raise your hand depending on how you are participating. For those joining us on a computer, tablet, or other smart device, You can raise your hand by clicking the blue hand icon at the bottom of the screen or by opening the participant window. For those joining by phone, please dial *9, after which you should hear audio confirmation of your hand being raised. If you wish to speak and you have not already raised your virtual hand, please raise your virtual hand now. The Planning Commission's decision will be the final city decision on this matter. If there are any further appeals after our decision, they will go to the State Land Use Board of Appeals. Before we start the hearing, I want to thank everyone again for your patience, your flexibility, and good humor as we work within this virtual meeting format. As always, feel free to connect staff if there is testimony you were not able to provide or wish to get to us in a different manner. Now we'll turn to the staff, and for their presentation, we'll begin with a brief presentation from staff. Lauren Summers, Assistant City Attorney, and Althea Sullivan, Assistant Planner, will provide information about procedural matters and the application at hand. Althea, I believe you're up.
Thank you, Commissioner Ramey. I'm gonna share my screen with everyone here. All right, is everyone able to see a screen that says public hearing at the top? If I could just get a hot head nod or two, that would be great. Okay. So I'll start by introducing myself. My name is Althea Sullivan. I'm an assistant planner with the city's planning division. I'm also joined by Gabe Flock, Jeff Gepper, and Amy Janish from the city's planning division, as well as Lauren Summers, who Commissioner Ramey introduced. I think that several of the people that have attended these hearings have probably been present for other hearings in our virtual world that we're all working in. But just a reminder for everyone, we will let you into the meeting to speak, and then you will be let out of the meeting. As Commissioner Ramey mentioned, we are asking that you do your best to keep your testimony to 3 minutes. We'll try not to cut you off mid-sentence, but if we're headed into the 4 or 5 minute realm with something, you will be muted and let back out of the meeting. This first slide just shows the order of presentations we'll go through. So we've already opened our meeting. I'm speaking now as staff. Then we will provide an opportunity from the appellant, who's also the applicant in this case, to provide their best arguments about why they appealed the hearings official's decision. And then we'll allow an opportunity for testimony from anyone else, because we can't have you fill out a form or communicate with us otherwise to let us know if you're for or opposed to the application. If you can just state that when you begin your testimony, as well as your address. And then we'll have an opportunity for staff to provide any responses, or for the Planning Commission to ask questions. And then finally, the applicant or appellant will have a last opportunity to make an argument. So hopefully this comes as a surprise to no one, but we're here to discuss the RNS management zone change request. This is an appeal of the hearings official denial of the applicant's request for C1 zoning. Just as a reminder for everyone, the property is currently zoned R1, low density residential, and the request is to rezone it to C1 neighborhood commercial. The property in question is shown in a green color with an arrow pointing to it. And then I will also show a zoning map, which shows the properties around it. Some of the property is zoned commercially, some of it is zoned residentially. Before I talk any more about the hearings official's decision, I want to address several other applications that have been turned in this area. So I think that many people are likely aware of a request to move a traffic diverter that's currently located on Fairway Loop. There was a hearing held for that, and the city's traffic engineer will be making a decision about whether or not to move that diverter. And then there has also been a request for adjustments to development standards For the properties, and on your screen, this is shown as GO, and then there's also a lighter yellow color to the north of that GO. That makes up one larger property. And there has been a request for some adjustments to development standards for an application for apartments. The planning director approved the request, and that's currently been appealed to the Eugene hearings official, who will be making that decision. The point in me sharing all of that is that city staff is aware of these other applications, and while we might want to have conversations about those or talk about those, we can do that. If anyone wants to give me a phone call, that's something we can have a conversation about. But tonight, the hearing is limited to the appeal of the hearings official's decision, and that's specifically about the zone change request to rezone the property from R1 to C1. So we know these other things are there. We can talk about them if you want to give me a phone call, but tonight we kind of have to stay limited to the zone change request. So I'll start with a little bit of background on how zoning works. This was provided as a slide at the hearings official's public hearing. So zoning starts off, and you could think of it sort of as a blueprint for the city that comes from a designation map and then guiding policy documents. Those documents are further refined by refinement plans. Those are area specific and have additional maps or policies. And then we end up with zoning in the end. We have two types of zoning. We have a base zone, which provides an allowance for certain uses and then set standards for those. And then we also have overlay zones, which often provide a specific process. So the hearings official's decision on this particular application found that the request was consistent with the Metro Plan. It did not find that it was consistent with the applicable refinement plans. Specifically, Willackenzie Area Plan has an Oakway sub area, which provides a map as well as some other policies. In that was policy 2, which the hearings official found the applicant had not shown that their request for C1 zoning was consistent with. And then the hearings official also found that the applicant had satisfied the transportation planning rule and had shown that the site could be served by key urban facilities, but did not meet siting requirements. And specifically, the siting requirement that was not met was the demonstration of an adequate support population for the C1 zoning. Following the hearings official's denial of the applicant's request, an appeal was received by the applicant, which raised 3 issues. The first 2 issues are related to specific approval criteria for the zone change. So the first one there, Eugene Code 9.88652, has to do with the refinement plan policies. That was where I was talking about the Oakway subarea policy 2 earlier. And then the second approval criteria is Eugene Code 9.88654, which has to do with the siting criteria. That's where I was talking about the adequate support population. And then the third appeal issue was an argument that the hearings official was biased, and that bias had influenced his decision in a way that had ended up in him making a decision that was too biased. So I want to pause here just to remind everyone that while there may be other issues that we might want to talk about, really what we're talking about this evening is whether or not the hearings official made an error in his evaluation of all of the items and arguments that were put before him that are in the record when he went to evaluate the approval criteria for the zone change. So each of the appeal issues, I will just read those for context for everyone. So this first one was the one related to the approval criteria with Oakway Subarea Policy 2, and it's the hearings official erred by misconstruing Willackenzie Area Plan Oakway Subarea Policy 2 as prohibition on rezoning the subject property from R1 to C1. The second issue was the hearings official erred by determining that the Eugene Code commercial siting requirement found at Eugene Code 9.21501 that new C1 zones shall be located within convenient walking or bicycling distance of an adequate support population was not satisfied. And third, the hearings official was biased, and therefore the hearings official decision was tainted by such bias and should therefore be reversed. With that, there's a couple procedural items worth noting. Around 5:15 this evening, I forwarded on a fairly large packet of additional materials to the Planning Commission. That is all testimony that I received before the hearing this evening before 5 p.m. I can see my email lighting up. It looks like I am still receiving testimony coming into my email at this point. So anything that comes in before the close of the record, I will forward to the Planning Commission after we leave the hearing tonight, so that I can be present and listen during the hearing. I'm not going to be doing that while we're all trying to listen. Another item that I'll mention here, I understand that sometimes timelines to provide testimony seem fairly short. In the state of Oregon, the city is required to reach a decision on applications within 120 days since after the application is deemed complete. What that means is even if someone wanted the record to stay open this evening, the city is currently required to meet a deadline, which doesn't look like we have time to hold the record open. I'll also mention again that the appeal is on the record about what happened with the hearings official. So while you might think of another argument or another thing to bring up related to an appeal issue, holding the record open wouldn't be an opportunity to go out and do a whole new study or collect a bunch of evidence and turn that in. I think with that, I will offer an opportunity to Gabe Flock and Lauren Summers if there's anything else that either of you would like to add. And maybe it's easiest if I call on Lauren first so we don't talk over each other on Zoom.
Althea. I just have a couple of comments that I want to echo some things that Commissioner Ramey and Althea have already said and reiterate them. So this is, as we've said a number of times tonight, a quasi-judicial land use application. That means it relates to either one or a small number of properties rather than a legislative application like the clear and objective update that Planning Commission recently considered that relates to a large volume of properties in the city. And as a quasi-judicial application, the parties to this decision have a right to an unbiased decision maker and to make sure that the Planning Commission is considering only the evidence in the record and only the appeal issues that were raised by the appellant, who in this case is the applicant. So to say it in a little bit of a different way, Planning Commission in this appeal is constrained in two different ways. The first is that you're only allowed to consider the evidence that the hearings official had. So you are being directed to place yourself in the shoes of the hearings official, to look at the evidence that he had access to, and to decide whether he got it right. You cannot, therefore, consider new evidence that the hearings official did not have access to. So testimony tonight can be focused on arguing to you about the evidence that the hearings official had access to, about trying to convince you whether or not he made the right decision based on that evidence. But testimony tonight should not include new facts or new information that the hearings official didn't have. To the extent that new facts or new information come up, staff will be asking you on Thursday when you begin your deliberations to make a statement that you are rejecting, that is, that you are not considering any evidence that the hearings official did not have. The other way that you are constrained in this appeal is that you can only consider the issues that are raised by the entity who has filed an appeal and are raised in their appeal statement. So in this case, the applicant is the appellant, and they have identified 3 appeal issues, which Althea just walked you through. You can consider whether or not the hearings official got those portions of his decision right. But if the applicant did not identify something as an appeal issue, then it is not before you and you cannot consider it. So there are portions of the hearings official's decision that you will not be looking at because they were not called out as appeal issues. So that's it from me, I think, unless there are any questions. I will hand it back to Althea.
Thank you, Lauren. And I'll just provide a final opportunity, Gabe, if you have anything else you'd like to add. And I'm getting a head nod, not a head nod yes, but a head nod no. So with that, Commissioner Ramey, I will hand it back to you.
Thank you, Althea and Lauren. Now I would like to open the public hearing of the Eugene Planning Commission. As a reminder to raise your hand, please click on the hand icon. And if you're joining by phone, please dial *9. Please give us your name and address before beginning your testimony and let us know if you are in favor, neutral, or opposed to the appeal. And as a reminder, we're going to limit testimony to 3 minutes tonight for all parties other than the applicant. The applicant will have longer to speak due to the fact that they appealed the decision. To help keep time, we have Commissioner Beeson, who is going to raise his hand when you have 30 seconds left. There's Commissioner Beeson. Thank you, Commissioner Beeson. And then he will let you know when your time has ended. The applicant will speak first, then we will hear testimony from others. As a reminder, at the beginning of your testimony, please provide your name and address and let us know whether you are in favor, whether you are neutral, or whether you are opposed to the application. The applicant will be given a final opportunity to respond after all other testimony is provided. So I believe we're ready to hear from the applicant now.
And Amy, if you can also let Mike Reeder in as well, please.
I will, thank you.
Good evening, Planning Commissioners. Can you hear me? Great. My name is Mike Reeder. I'm an attorney representing the appellant and the applicant, RNS Management, LLC. With me tonight is a representative of the applicant, the owner, Sarah Bennett. Also with me is Zach Galloway, land use planner, and Kelly Sandow, transportation engineer. Sarah's going to first speak briefly, and then I will speak. Kelly and Zach are available to answer any questions, but as has been discussed by Ms. Summers and Ms. Sullivan, the transportation issues are not before the Planning Commission at this time. So I'm going to go ahead and turn the time over to Sarah Bennett, after which I will speak.
Hi there, can you hear me okay? Am I on camera? No, okay. Good evening, commissioners. My name is Sarah Bennett. I live at 680 Fair Oaks Drive. Tonight, I'm representing my family, who are the owners of the property on Fairway Loop in Southwood, under review for the zone change. I'd like to leave the technical aspects of the zone change up to our planner and our attorney. But first, just want to say a few things, a few general things that are important to us as a family. First, we are a third generation Eugene family. We ourselves have lived in the adjacent neighborhood to the north for over 25 years and own this parcel of land for almost 20 years. During the entire time this parcel has been zoned R1, and we have known that single family residential is not the appropriate zoning. It sits along Southwood with no access to Southwood. It is up against the freeway, and basically is an island. We don't yet have a plan to develop this property, and we recognize that this is not a standard primary retail site. We're not suggesting that it should be primary retail. The reason we picked C1 is that, for example, if we put multifamily housing on the site, it might give us an opportunity to have a small retail spot on the bottom floor that would appeal to the neighborhood, like a barber shop or a coffee shop. It's such a central linkage point with all the walkers and bikers that go by. You know, we may not decide that we want retail in the bottom. We might just park underneath the building, but at least C1 will give us a little more flexibility. Lastly, because we've been part of this neighborhood and the greater city of Eugene for so long, you know, we have a pretty transparent record of caring a great deal about the community. And, you know, we have a history of building high quality projects, which we have every intention of doing with this project as well, once we have the opportunity to plan it. So thanks, I appreciate you allowing me to comment very much.
Thank you, Sarah. This is Mike Reeder again. My office address is 375 West 4th Avenue, Suite 205 here in Eugene. Again, representing the applicant. Planning commissioners, thank you very much for your service. Thank you for taking your time this evening to hear a planning commission appeal of the hearings official's decision that we feel was in error in 2 primary matters, although there's 3 appeal issues. So I want to start off first by saying the hearings official got many things right. There were many issues that were brought before the hearings official. Many issues were not relevant to this particular zone change from R1 to C1. And I feel that that got his decision a bit muddled, which is why our 3rd assignment of error talks about bias. Now I want to explain a couple of things regarding bias. One is, in my career as a land use attorney, I've never actually challenged a decision maker for bias. This is the first time I've raised it. The reason I raised it is because the last page of the hearings official decision discusses other issues. And in that discussion of other issues, it was clear that the hearings official was persuaded by and sympathized with what he considered the plight of the neighbors. He discussed it as being a death by 1,000 cuts and discussed, you know, the analogy of Lucy pulling the football away from Charlie Brown. Those comments seem to have clouded the decision making and I believe had an effect on the 2 issues that are the appeal issues that I'm going to discuss tonight. I want to be clear though, you as the planning commission can cure that bias. So it's not an assignment of error that would go to LUBA. You as the planning commission in your roles as volunteers, as decision makers, are able to make your own informed, unbiased decision. And I'd like to commend the Planning Commission. I've seen you in action lately, and I appreciate the work that you do. I appreciate the work that planning staff does as well. So let me get into the heart of the appeal. There are 2 assignments of error, 2 appeal issues. Again, the hearings official got many things right, many things that we agreed with, but on these 2 issues, we believe that he fell short. As was discussed by Sarah, this project, this site, is an island of R1 zone property surrounded by land designated by the Metro Plan diagram, as well as the Willackenzie Area Plan land use diagrams as commercial on the north, east, and south. A small property to the immediate southwest at the intersection of Southwood Lane and Fairway Loop is designated medium density residential. The property to the immediate west is commercially developed private golf course, the Eugene Country Club. In a manner of speaking, this property is miszoned. A rezone from R1 to C1 would correct that miszoning. The subject site is a prime candidate for a commercial zone, such as C1, that allows for, but does not mandate, mixed-use development. C1 is more flexible than R2 because of this mixture that's allowed. The subject site is located within the center of Eugene along a key transit corridor and very close to I-105. It is not appropriate for R1 zoning. A rezone from R1 to C1 implements the policies adopted as part of Envision Eugene. And in my memorandum that I sent to staff today, that hopefully you have a copy of and will have an opportunity to review, I outlined the Envision Eugene policies that you're probably very familiar with, and why this particular zone change application fits the mandates of those pillars. I'm not going to rehash those tonight, but I will provide you a highlight of the legal analysis that needs to be done as you analyze these two issues. So like I said, there are two issues. One issue is the interpretation or the characterization of the Willackenzie area Oakway sub-area plan policy number 2. And the second is an interpretation of the C1 development standards regarding what is an adequate population base for C1. So first I'm going to talk about the first issue, the interpretation of Willackenzie area plan, or Willackenzie area Oakway sub-area plan policy 2. And you may be familiar with this plan policy as you prepared for this hearing, but I'm going to repeat it for clarity. So the policy states this: the city shall limit commercial and general office development to those areas currently zoned for commercial and general office uses. The hearings official determined that this particular plan policy was mandatory and that it has the effect of prohibiting this particular property, or actually any property within the Oakway sub-area, of being rezoned to commercial, such as the C1 zone. The hearings official erred. The hearings official erred because this policy not only is not mandatory, but even if it was mandatory, it's a policy that must be weighed and balanced in the context of all other plan policies adopted by the city. So there's basically two sub-issues. The first issue I'm going to talk about right now has to do with proper interpretation of the Willackenzie area plan. Oregon law requires that when a decision maker, such as the hearings official or the planning commission, interprets code or plan policies, land use regulations that have the force of law, that they must follow a certain methodology, and that methodology is found in case law. Most land use attorneys know this case law by heart. It's the PG&E and Gaines methodology. And what that says, the Oregon Supreme Court has said that when interpreting code, the job of the decision maker is to find the intent of the actual drafters of the law that's being interpreted. And in order to find the intent, what a decision maker must do is not only look at the actual text that's being reviewed. So in this case, the text is policy 2, but also look at the text in context. And the context in this case includes the Willackenzie area plan and the provisions contained therein. And I've provided you a list of contextual provisions in the Willackenzie area plan that can help you as you determine what the correct interpretation of this policy is. The hearings official got tripped up a little bit in deciding, making a determination that the term development included zone changes. In other words, he interpreted policy 2 to say that you cannot do a zone change to commercial in this Oakway sub area. That is not what this plan policy says. The hearings official erred by not looking at the context of the Willackenzie area plan. But looking at the other policies contained in the Willackenzie area plan, it's clear that the drafters of the Willackenzie area plan knew how to discourage, limit, or prohibit rezoning in specific areas if they so chose. And below are some examples of where the Willikinzie area plan makes such distinctions between development, uses, and rezoning. And I'm only going to, I provided you quite a few of them, but I'm going to just focus on two for brevity tonight. The first is Delta Subarea Policy 1, found on page 48 of the Willikinzie Area Plan. And I'm going to quote this policy. This policy says the city shall limit commercial and general office development to those areas currently zoned for commercial and general office uses, and shall discourage any future commercial rezonings in this area. Now compare that text to the text of policy 2, and you will notice a difference. The hearings official impermissibly included text in his interpretation in contravention to the statute that prohibits decision makers from doing so. That provision is not to insert what is omitted, and not to omit what has been, not to insert what's been omitted, and not to omit what has been inserted. In this particular case, the hearings official impermissibly added rezonings as a prohibition in policy number 2. Another great example of the Willikinzie Area Plan provision that provides context as you interpret this is Gillum Subarea Policy 2, page 23. And this states as follows: expansion or redevelopment of the neighborhood grocery at the northwest corner of Cal Young and Fur Acres shall conform to Willikinzie commercial siting and development guidelines, and shall be limited to the existing tax lot. This site shall also be limited to neighborhood commercial zoning. One more policy that I want to highlight is policy, Good Pasture Island Policy 8, page 45. The city shall discourage rezoning of land for commercial uses within the area north of West Delta Ponds. And the list goes on and on. I have provided you a couple of pages worth of those policies. In short, it's clear that the drafters of the Willikinzie Area Plan and the city council that adopted it knew when to limit certain types of development and how to control particular zoning in particular sites. And when they wanted to prohibit or discourage rezoning, they said so. They did not say so in policy 2. They clearly made a distinction between development use and rezoning, and a proper PG&E State v. Gaines text and context analysis conclusively shows that the hearings official erred when he interpreted policy 2 to prohibit the rezoning of the subject site. The second part of my argument regarding assignment of error number 1 is an alternate argument, which is, and it's one that was totally missed by the hearings official. The hearings official in his decision did not address this argument. And that's that even if you consider the language of policy 2 to be interpreted the way the hearings official suggested it should be interpreted, which I just explained he shouldn't have. But even if he did, he still erred. And that is because the Willikinzie Area Plan policies establish that the individual policies, such as the Oakway Subarea Policy 2, are not strictly mandatory, even with mandatory text such as shall. So you'll notice in policy 2, it says the city shall limit commercial and general office development. And I explained to you just now that that doesn't prohibit zone changes. But even if it did, the hearings official erred when he determined that the word shall made this policy strictly mandatory. Case law and an analysis of the Willikinzie Area Plan refutes his conclusion. While addressing and dismissing some of our arguments, he failed to even address this issue that was raised. And I provided it for your convenience in the memo that I provided to you today. The Willikinzie Area Plan policies, this is what the policy section of the Willikinzie Area Plan says. It says, policies are statements that suggest, and I would emphasize the word suggest, a specific course of action that will move the plan towards attainment of its goals. policies are adopted by the city council as guidance for decision-making within the plan area. City programs, actions, and decisions will be evaluated on the basis of their ability to implement adopted policies in this plan, and I would emphasize, as well as other adopted city goals and policies. Because policies are adopted by the council as the city's guide for action in this area, policies are the most important statements of the plan, in contrast with proposed actions and findings. In other words, even if Oakway Sub-Area Policy 2 is interpreted as the hearings officer did, the hearings official did, to limit or prohibit zone change applications to C1 in the residentially designated areas, this policy is a suggestion or guidance to be balanced and weighed with other adopted city goals and policies. It's certainly not strictly mandatory, and when balanced with other city adopted goals and policies, it's clear that the zone change application from R1 to C1 that will allow mixed use development should be approved as implementing other city goals and policies, particularly the pillars of Envision Eugene, which suggest intense increased development along key transit corridors. So I represented a landowner who owned property outside of the city of Eugene during the Envision Eugene process. And they were very disappointed because they were not able to, their property was not brought into the urban growth boundary at that time, because Envision Eugene, through the public process, the community decided not to grow the urban growth boundary for residential, but to intensify development along key transit corridors. And many of you were involved with and are aware of that process. This is a zone change from R1 to C1 will help implement those policies adopted as part of the pillars of Envision Eugene. And it is within that context that you, the Planning Commission, should be weighing and balancing these policies. I'm going to briefly pause here to see if there's any questions before I move on to assignment of error number 2. I'd be happy to answer any questions that planning commissioners may have at this time. If there are none, then I'll go to assignment of error number 2. There is an adequate support population for this particular C1 property. The hearings official erred by determining on page 8 of his decision that there was not enough information in the record to make a finding that there was, quote, not adequate support population for the subject site. The hearings official did not explain when he stated that the applicant could not rely on the city's interconnected bike and jogging trails to connect the site with the city at large to provide the adequate support population. This is, quite frankly, unreasonable, and it's kind of flabbergasting. The code explicitly allows for the inclusion of the city's bicycling paths. And in fact, in 2 other decisions that are actually in the record, the Benson and the Coburg Place LLC zone changes, which included zone changes from R1 and some others to C1. So we're specifically talking about C1, and we're specifically talking about the Willett-Kenzie area plan. Mr. Wilson did properly look to the bicycle facilities, and he reached out 2 miles to bring in 10,000 and 14,000 parcels respectively. In those cases, he actually did make a correct determination that bicycle facilities are to be used in the determination of whether or not there's an adequate support population for C1. In fact, in one of his decisions, he says it's expected that bicyclists would bike to the site as there are more than 14,000 parcels within biking distance 2 miles of the site. And that was in the Coburg Place LLC zone change application. The hearings official also discounted without explanation the support population of the residential neighborhood to the north. So the future residents of the property to the north, that's currently the subject of the adjustment review application that was referred to earlier tonight, as well as the community members that use the minor arterial Southwood Lane. Perhaps an even larger omission by the hearings officials that he failed to address the commercial and employment areas in the Oakway area and the Country Club Road area as part of the support population. The neighborhood support population includes commercial and office workers and visitors, as well as residents. It should also be noted that the C1 standards that talk about an adequate support population do not provide a numerical minimum or maximum for properties that are less than 4.5 acres. This property is less than 2 acres. So it is not the applicant's responsibility, nor is it the hearings official's duty to determine what the actual numerical value should be for an adequate support population. That to do so would make that the application of that provision void for vagueness. It's too vague. But this planning commission can reverse the error of the hearings official by determining that there is an adequate support population based on the fact that this site, and this is all in the record, this site is in the center of the city of Eugene, which is within the second largest metropolitan area in Oregon. It is close to parks, Alton Baker Park. It's close to other amenities, and it's close to the Ruth Bascom Riverfront trails, which is one of those amenities that is going to be so important for the site, and one of those amenities that's important for the community. I would argue that it's patently obvious that there's an adequate support population for the subject property. The area within the 2-mile radius of the site includes downtown Eugene, the Whitaker neighborhood, and the entirety of the Cal Young and Harlow neighborhoods extending east to I-5 and north to the Pape Beltline. Even without an exact count of the residentially zoned lots, it's reasonable to conclude that the support population within convenient walking and bicycling distance from the subject site is much more than adequate. It's overly adequate. And it's described in the materials in the record, the public infrastructure exists to support walking and cycling. Essentially, it's like saying the sun is hot and water is wet. There is an adequate support population here. In conclusion, the hearings official erred by misconstruing the meaning and effect of the Oakway Sub-Area Policy 2 and determining that the record was insufficient to determine that the subject site was supported by an adequate support population, and his decision should therefore be reversed and the application should be approved. I'd be happy to answer any questions you might have, and I am available to respond to any comments that are made during public testimony.
See, we have Commissioner Borofsky. Commissioner Borofsky, is something that can wait or something you want to have answered right now?
Well, I'm not sure about the procedure. I do have a question that pertains to the Willackenzie area plan policy number 2. And I was hoping that Mr. Reeder could speak to it. But I can do that at whatever time the chair feels is appropriate.
I think we should hold that, and we'll do that after testimony. We'll have questions at that time.
Thank you.
Okay, now we're ready to have others testify. And remember to raise your virtual hand or press *9 if you would like to provide testimony. Remember to mention your name and your address and whether you're for, neutral, or against. Staff will let you in.
So we have 2 hands up. We have Liam Sherlock, and then next will be John Thomas.
Good evening. This is Liam Sherlock. I'm a land use attorney here in Eugene, and I represent the Fairway Loop Neighborhood Association in this appeal in support of the hearing official's decision denying the application as not having met the appropriate approval criteria. I'd like to just start quickly by addressing this interpretation rule that Mr. Reeder pointed out under the PG&E Bureau of Labor. I think Mr. Reeder didn't quite explain that the first precept and requirement of that Supreme Court case is that if a rule, or in this case, a policy, is clear on its face and the intent is obvious, then no further inquiry is necessary, and including the contextual analysis that Mr. Reeder is proposing. In this case, the hearing official did determine that the proposed zone change cannot be approved consistent with the Willackenzie Area Plan. The policy 2 that is at issue here, well, and I'd also like to point out as a precursor to that the City of Eugene zone code says that a zone change shall not be approved if it is inconsistent with an applicable refinement plan. And that's at Eugene Code 9.8865. We put in our letter that we've submitted to Althea to be distributed. An approval of a zone change application, including designation of an overlay zone, shall not be approved unless it meets all of the following criteria: consistency with the measure plan and refinement plan. And there's no question that you cannot, and as the hearing official found, you cannot get a clearer policy, mandatory policy than policy 2. The city shall limit commercial and general office development to those areas currently zoned for commercial and general office uses. It doesn't say may limit commercial and general office development. It says shall not. So that is the key here. It's a mandatory provision. There's no wiggle room. It's clear on its face. And to try and parse out various other of the multitude of other plans and policies, plan policies that Mr. Reeder is trying to muddy the water on this is both inappropriate and as the hearing official found, it's inaccurate. This is as clear a direction as you can find in a refinement plan, and it should be adhered to, which is what the hearing official did as a matter of law. The applicant is making two arguments: one, that it's not mandatory, and two, that it's doesn't pertain to development. Well, we've kind of addressed that first one. The second, though, is whether it's development or not. But as the hearing official pointed out, the WAP, the Willackenzie Area Plan, identifies zone changes as private development proposals. The plan itself says, and this is quote, is to serve as a basis for evaluating private development proposals, such as zone change requests. That's at page 1 of the WAP. So private development does include zone change requests. Of course, it's a common sense approach to how development in this metropolitan area proceeds. The second assignment of error deals with whether or not there was this adequate support population. And the hearings officials simply found there was not an adequate evidence in the record to support the proposal for the proposed commercial zone. It's a neighborhood commercial zone. It's not a community-wide. It doesn't matter that Eugene is one of the second largest metropolitan areas in Oregon. It's not about the population as a whole. In addition, this site is not right on the Riverbank Trail. This is not the North Bank restaurant or the commercial complex. We're actually on the Riverbank Trail. And to suggest that this is because it's tied to pedestrian sidewalks and a bike path that's actually some distance away along the river, that it links this whole community to this and supports this proposed commercial rezone is simply not accurate. It's not the criteria doesn't focus on the Eugene as a whole. It's focused on whether the local population in the neighborhood would support this commercial neighborhood use. And the hearing official appropriately found there wasn't enough evidence in the record to support a finding to justify approval based on that criterion.
Mr. I'm sorry to interrupt you. You're going a little bit beyond your time, well, actually quite a bit beyond your time. So I'm hoping you can wrap it up quickly here so we can.
Absolutely, I will do so. There was quite a lot of information to try and respond to.
We have just a few other people testimony, so a little further overrun is perfectly okay, but you need to think about wrapping it up.
I appreciate that, Mr. Chair, and I will do so right now. To conclude, the hearing official appropriately looked at all the facts, analyzed the law. This hearings official is an experienced land use attorney and did in fact correctly apply the appropriate standards. I just briefly addressing the accusation of bias. I heard Mr. Reeder say that the hearings official, quote, got many things right. And I don't think that supports any kind of a rational finding that the decision that was rendered was a biased decision. I think the hearings official was simply showing some expressions of sympathy given the bifurcation of this land use decision-making process for this property, but that does not justify a biased determination. And I would urge the commissioners to reject that as well and uphold the hearings official's decision as the right one. Thank you very much.
Thank you, Mr. Sherlock.
So next up, we'll have John Thomas, and then after him, Laura Bodner.
Go ahead, Mr. Thomas, if you can hear us, go ahead.
And Amy or John, you may be muted at this time. Amy, I don't know if you're able to unmute John.
Okay, can you hear me now?
Yes, we can.
Okay, thank you. My name is John Thomas, 2093 Eastwood Lane, and I support the original denial, and which is obviously contrary to what the appellant is trying to do to reverse that through an appeal process. 2 points I'd like to make, and Mr. Sherlock has made both of them quite well, so I'll be brief. The first is the refinement plan. The hearings officer was very precise in his comments that this does not meet the definition of the refinement plan, which is a sub-plan for the metro plan. And if it is only serving as a guideline with rough broad-based parameters, why even have a plan? Why have codes when you're not going to address the specificity of those codes? So we think that the hearings officer was very complete in his findings and that this proposal did not address the codes and the standards that are in that refinement plan. The second is the proximity, which would be, I think, under 9.2150 paren 1 paren. Because if you know this area, the nexus is not very close to anything that has to do with bicycle traffic. In order to get your bike out to the bike path, you have 3 different intersections you have to go through. So this is not something that is along, the bike path by North Bank, McMinimans, and it really, people going down Southwood Lane, that is an extremely busy thoroughfare. It's actually a state highway. You see very, very few bicyclists because it's dangerous. So in terms of being able to support neighborhood commercial by using a population that the appellant is saying is close by, I think is a point that really has to be carefully examined, because there's nobody that I know in that surrounding area, even the 35 apartments there where Country Club Road and Cedarwood Lane intersect, they're not going to walk down that Southwood Lane, and they're really not going to go through 2 different intersections to get to a neighborhood commercial. And there's nobody that I know that are in the abutting neighborhood, north neighborhoods, Eastwood, Westwood, that are going to walk down there to a barber shop. So again, I think the hearings officer was very judicious when he reviewed this and he found out and he made his findings. So I would hope that the commissioners, and you have fiduciary responsibilities, even though each one of you probably has different constituency issues, but the common denominator is that you are a commission and you need to be united in terms of how you approach things that tie into your fiduciary responsibilities as mandated by the city of Eugene. So thank you for the opportunity to present.
Thank you, Mr. Thomas.
So now we'll have Laura Bodner and then Sandra Wu.
Hello, can you hear us?
Yes.
Yes.
Hi, my name is Micah Bodner. I'm here with my wife, Laura Bodner, and we live at 2061 Eastwood Lane. We're on today to support the original decision to deny the rezone. First, I'd like to agree with the points that John and Liam have made, and I won't go through those again. But I guess I would like to add something new by addressing the content of the appeal to that decision that we heard today. As a resident of the neighborhood to the north, I do find the appeal quite concerning. The crux of it really is that Mr. Reeder thinks he can dictate to you how the Willa-Kinsey area refinement plan is to be interpreted, and to suggest that it doesn't need to be followed. As residents of the neighborhood, we bought here expecting the integrity of the neighborhood to be upheld. We plan our lives to raise our children here, and we really expect the Willa-Kinsey area refinement plan to be followed. I think it's also a little frustrating to see that other arguments include trying to discredit the official who made the decision. It seems a little bit like a policy pattern. You know, I've been on several calls disputing some of the changes that are trying to be made in our neighborhood, many with Kristen Taylor, and only tonight did I just find out that she was a city commissioner. So while this may not be the type of information you can make a decision with, I am concerned with the content of the appeal and this seeming pattern of how the developer is going about their business.
And may I add 2 cents? My name is Laura Bodner. You know, I'm not completely well versed in the Envision Eugene, but he's saying that that is something that is a goal of Eugene that needs to be balanced. And my guess is that it would be that, you know, the urban growth boundary was not expanded and that high density housing is needed in Eugene. And, you know, we understand that. However, I think it sets a very dangerous precedent if we allow them to not follow the Willa-Kinsey area refinement plan, because it's very clear in its intention. You know, you can argue semantics, but its intention is very clear. You know, the Willa-Kinsey area refinement plan was put in place to uphold the integrity of existing neighborhoods. And whereas new housing is needed, you can't do that at the expense of neighborhoods that already exist. So I would urge you all to think about how, if you allow this bypass of the WAP in this instance, you know, how that might be looked at in.
Oh dear. I fear we have lost you, Laura. Give you a moment to reconnect. Well, let's do this. Let's see if they come back and re-raise their hands. I think, Commissioner Beeson, where were we on time?
We were doing okay. I was ending up giving each one of them 3 minutes. So they had about a minute and a half to go. We were okay.
Let's move on to the next speaker. And if they're able to reconnect, we will, I think they were about done, but let's see how it goes.
So next up we have Sandra Wu.
Hello, can you hear me?
Yes.
Thank you. My name is Sandra Wu. I live at 2024 Eastwood Lane, and I am opposed to the appeal by RNS Management. And first, I want to say that the third issue where the hearings official was said to be biased because he expressed sympathy with the opponent's plight is an egregious mischaracterization of the official's attitude. Sympathy for one side or another is not bias. I would just like to agree with the Bodners and John Thomas and Liam Sherlock in my, and I guess express my frustration that these three issues that have descended on our neighborhood in rapid succession, one of them being the rezoning, one of them being the movement of a traffic diverter, and apartment code adjustments have ramifications on each other. And what happens if all of these things are approved is that we have an increase of traffic bypassing the diverter, which the Willackenzie area plan put into effect in the year 2000, because we had an excess of 2,000 vehicles per day coming through the neighborhood. It was an unsafe situation. In the year 2000, the barrier was erected. And all of these proposals by the developers are going to invalidate the Willackenzie area plan. We, by the traffic engineer, by the traffic transportation analysis, by the developer's own traffic analysis, Sando Engineering, the worst case scenario is 2,640 average daily trips into Fairway Loop and Eastwood Lanes, which are unimproved streets with no sidewalks, no gutters, basically you can't have two cars passing by each other and people on the road at the same time. So we just, I know that this is not the time to bring it up, but I would like to ask you commissioners, what is the right time for us to bring up these traffic issues? Where are we going to have our hearing? When are we going to have our hearing? This affects the livability of our neighborhood, the safety of our streets. When is the proper time to address this? That's all I have. And thank you very much for hearing me out
this evening. Okay, I think we can circle back now and see if Micah and Laura wanted to finish up. Can you hear me, Micah and Laura?
Yes, I apologize.
Oh, that's fine. So if you could just summarize where you were, we'll give you a few moments here to summarize your testimony.
Okay, I believe, I don't know exactly when I got cut off, but I was saying, did you guys hear the part where I was saying that City of Eugene needs high density housing? Yes, right. And so that's the Envision Eugene that he's talking about, right. Balancing priorities. But I just have one last thing to say is that, I feel like it sets a very dangerous precedent if we allow developers to circumvent land use laws because high density development, high density housing is needed, and that we need to uphold the land use laws because you can't just diminish the integrity of the existing neighborhoods to achieve that goal. So that's all I had to say, that it's a dangerous precedent to set.
And I think you heard all I had to say, but the crux of my arguments were just that, you can't either dismiss or try to reinterpret the Willackenzie Area Refinement Plan, and that you can't try to call into question the integrity of an official who made a decision you don't like, and trying to leverage the bike path as a reason to say that you have an adequate support population just doesn't make sense. I mean,
Right, you'd have,
Any place in town could claim the entirety of Eugene and Springfield, you know, for development purposes, if that's the case.
all right, I believe that's it.
All right.
Thank you for letting
Very
us.
much for your time. Really very helpful. Appreciate it. Are there any others who wish to provide testimony at this time?
We do have Jaden P. whose hand is up.
Okay.
Hello, can you hear me?
Yes.
Okay, my name's Jaden Phoenix and I'm at 2077 Eastwood Lane. And I am opposed to the appeal in the original application and hope that you uphold the hearings officer's ruling on the rezone. I do want to say that as neighbors, we don't really always know all of the technical details and codes and laws. And I do know that at the previous hearings, a hearing that we had for this rezone, we did bombard the hearings officer with quite a lot of our frustrations with all of the differing hearings and applications that had been in play at the time, because we do feel that they are all related. And I really appreciated that the hearings officer let us know in his statement at the end that he heard us and that he understands that it's frustrating and that we hadn't had a forum for our traffic concerns. And he clearly stated that unfortunately, as much as he understands all of this, he could not use any of that in making his decision. And I did not feel that this represented bias and actually felt like it was a very good faith effort at addressing quite a large portion of that hearing that did not have anything to do with the actual rules and laws and things that you were supposed to be looking at for the rezone. So I did appreciate that and did feel a bit that we were heard. I do think that it's being brought up now as and being interpreted as bias because you know, there isn't a strong reason against these arguments that the hearing officer put forward in order to appeal. And so this idea, of course, they've already mentioned the bike paths not even being close here. And also the fact that other rules that weren't interpreted in his favor, Mr. Meter is now saying just simply don't apply to him. These, I'm sure there are finer points and details that I don't understand, but I do think that there is, you know, there is difficulty in trying to make these decisions out of context. Why, for example, are you requesting a rezone for a property that you have no development for? Well, you know, what the neighbors were able to find out is it's because they will not, the apartment complex will not be approved with the current plans unless it is rezoned because the buildings are too tall that they've, you know, proposed. So this is why we need to look at this rezone now. But how can you know that it's not supposed to be a part of what you're considering, right? I know all of this was brought up in the previous hearing, so it is in all that testimony, pages and pages of it. So that's it. Thank you for listening. I appreciate your time. Thank you so much for all you do.
Thank you, Jaden. Thank you for coming this evening. All right, now, are there any others who wish to speak? So I think this is the time. I don't see any others. Just give a second here to be sure that. I believe this is the time of the evening where we have questions or response from staff. And I think Commissioner Brodsky, this would be the time for you. I see Althea's hand went up briefly and then went down again. So maybe that's just a quirk of the technology here. So Commissioner Brodsky, yes, go ahead.
Thank you, Chair Ramey. couple of questions, and this can be either for staff or the applicant's attorney. First question I have is, this goes probably to staff. Is the hearings officer, Mr. Wilson, the same person who helped, who is the management analyst when drafting the Wilkinson area plan, and the staff person from back in 1992? And this goes to what the Mr. Reader brought up about legislative intent. If he was involved in drafting this plan, that may help get to a legislative intent and possibly bias.
So I'll take a quick crack at that, Commissioner Borowski. I don't know if any of us can actually answer your question, but my strong suspicion is that information is not in the record. And it also, when you talk about the intent of the plan drafters, what we're really talking about is the intent of the policy body that adopted the plan, which in this case would be the Eugene City Council. So it would, the management analyst specific intent doesn't matter, just like staff today, planning staff today's intent in drafting clear and objective updates that's not the intent.
Okay, well, it is in the record. His name is on the title page of the Wilkinson area plan. So that is in the record. So I just wanted to know if it was the same person. That's all I was asking for there. Now let me go back to the page that I was looking at, and this goes to a different section of the Oakwood sub area. I had a question regarding policy number 6, and wondering if that's applicable to this property, because it says the city shall recognize the area east of Fairway Loop and south of Eastwood Lane, and then it gives a tax lot, as depicted on the Wilkinson land use diagram as being appropriate for commercial development. Does this property fit that description? Because when I looked at the plan, it seemed like that property falls east of Fairway Loop and south of Eastwood Lane. So if that's the case, we have in my view, we have conflicting policies within the Oakway sub area. So I just need to have some sort of before deliberations, I'm going to need some sort of clarification on that, either from Mr. Reader or from Althea, to see if that policy, if this piece of property is designed in policy number 6 of the Oakway sub area. Those are a couple high area questions for right now.
Thank you, Commissioner Borowski. The staff have anything to fill in at this point based on, oh, I'm sorry, Commissioner Fregala, your hand is up. Go ahead.
Thank you. I was hoping that staff could give me a little background information on adequate support population. It's not a term I've run across before in any of our conversations. How would you define it? And I mean, I got some sense through the testimony tonight, but I'd like to hear how that's typically defined in planning and maybe hear an example.
Thank you, Commissioner Fragala. I think I will allow Mr. Reader, if he chooses to provide his own interpretation of that, respond in the testimony, and I will have something prepared for you ahead of deliberations to respond to that.
Thank you.
Anything else from staff or commissioners? Okay, then.
I was just going to confirm that I don't have anything else at this time. Not even hoping you understand that.
Thank you. So now is the opportunity for the appellant and applicant, one of the same, for any final rebuttal at this moment. So I presume this is Mr. Reader's hand is up. So as soon as you can hear us and you're ready to go, Mr. Reader, take it away.
I'm ready to go. Thank you, planning commissioners. Again, for the record, my name is Mike Reader for the applicant appellant. I'm going to go through, since this is not your typical, this is not a de novo hearing, I'm going to go through somewhat methodically and respond to the issues that were raised in the public testimony. So bear with me as I do that. I'll try and be as brief as possible, but also answer the issues that were raised and answer your questions. And feel free to interrupt me if you have questions that occur to you at this time. So first of all, I want to respond to probably one of the most important issues that was raised. It was raised by Mr. Sherlock, and he took issue with my analysis regarding your interpretive role regarding the PG analysis. And he said the first fundamental, I mean, I'm going to paraphrase, but the fundamental issue in interpreting a law is to determine whether or not there is ambiguity. Well, clearly there's ambiguity here regarding policy 2. We all have questions about it. The hearings official had questions about it. That's why there's ink spilled in the hearings official decision regarding how to interpret policy 2. Case law tells us that that bar for ambiguity is quite low. And in fact, the PG&E case itself on page 612 talks about ambiguity, and it says that you can have ambiguity even if there's a plausible interpretation that is less important or less persuasive than another. If the policy is capable of more than one plausible meaning, then there's ambiguity, and that's when you, as the Planning Commission, step in to interpret the policy 2. So there is ambiguity, and therefore you are required by the Oregon Supreme Court to go through a contextual and textual analysis. Mr. Sherlock did exactly what I anticipated he would do. He focused on one word. That one word in the policy 2 is shall. There is case law that indicates that the word shall, in some contexts, is mandatory language. And so the question is the word shall for policy 2, does that make policy 2 an independent mandatory criterion that stands alone? Or is it something else? And I would suggest to you that in this particular case, policy 2 is something else. And that is that the Willikinzie Area Plan drafters and the City Council that adopted the 1992 plan made distinctions in the plan itself between development, uses, and rezones. And when the Willikinzie Area Plan wants to limit or prohibit rezones, it says so. Policy 2 does not limit rezones. On its face, it doesn't. That's issue number 1 that I explained. Issue number 2, which I already went over, is even if you were to accept the hearings official's determination that policy 2 is mandatory, the Willikinzie Area Plan itself, the actual text of the Willikinzie Area Plan, says that even those mandatory policies are to be weighed and balanced. And that's found in Bothman versus City of Eugene, 51 Orluba 426. And that case is important because it's a case that analyzes the Willikinzie Area Plan. And it goes, and Luba and the Court of Appeals actually went through and talked about policy statements in the plan. And it goes through and it says the exact nature and extent of the role played by any Willikinzie Area Plan depends presumably on the actual text and context of the particular policy. And that even if, while there's a preference for a policy decision to go one way, that preference is not, and this is, I'm quoting from the case, that preference is not absolute and can be overcome by sufficient reasons and or competing policy considerations. Read in context, the policy clearly requires the city to at least consider Okay, so you have the opportunity to consider the plan policy, but you have to consider what it actually says. It doesn't prohibit rezones. It prohibits development, and commercial development can occur in the residential zones in certain circumstances, including through the PUD or CUB process. So that's what that policy is talking about. It's not prohibiting rezones. And as I said before, the plan lets us know when it wants to prohibit or discourage rezones. And it did not do it here. Okay, responding to, let's talk about some facts that are judicially noticeable. So for example, you know, by looking at a Google map or just knowing the area, that the Ruth Bascom Trail is adjacent to and across the street from Southwood Lane, across from this site. You get on the Ruth Bascom Trail across the street. It's, and there's bike lanes on Southwood and Oakway that connects this site to the neighborhood at large. So I'm somewhat flabbergasted at the response of the opponents who say it's not well connected. Now, there is an issue that this planning commission can determine whether or not you take in all of the residents who can conceivably get on the Ruth Bascom Trail. Everybody in the city of Eugene, 174,000 people. No, what we're talking about is what the hearings official did in those other two decisions, Benson and Coburg Place LLC. And in those decisions, again, those decisions are in the record, so you can actually look at them. And what they say is they looked at, the hearings official, Mr. Wilson, looked at the parcels within a quarter mile of the subject site within walking distance, and then looked at the biking facilities and how many parcels could be captured within 2 miles. This site clearly has an adequate support population. And even if there was the hearings official just did his best and said, well, based on the size of this parcel and the fact that there's a 4,000, there's a population of 4,000 if the site is between 4.5 acres and 5 acres, we're going to look at 1,333 and we're going to use that. Well, the problem is that's not what the Wilkinson area plan says. That is, that's ambiguous, and he's just inserting what has been omitted. There was some discussion from the neighbors about why even have a plan if there's this flexibility. Well, the reason is because things change and the plan itself provides for flexibility. And again, I read to you those provisions of the plan that do provide that flexibility and require the decision maker to weigh and balance other policies, including the Envision Eugene pillars. We, the applicant, are not asking this body to skirt or go around anything. Reasons for the zone change. Well, first of all, reasons for the zone change aren't necessarily germane to the issue at hand, but to set the record straight, the reasons for the zone change is for flexibility. And the site to the north is not dependent on this zone change. But this allows for a mixture of development or either commercial with residential or just commercial. But the fact of the matter is it's along a key transit corridor, and that's what the city Envision Eugene policies are all about. Bear with me for one moment where I make sure that I've addressed all of the issues. Regarding the question of Mr. Wilson, whether or not he was a member of the Wilkins area plan, I think it's extremely doubtful, but I'm not sure it's in the record. And Ms. Summers is correct that the PG&E analysis is to look to the intent of the decision-making body. In this case, that was the city council. There was no legislative history offered either by us or by anyone else that would give us any additional clues as to what the meaning of policy 2 was about. Lastly, I want to talk about bias. Again, as I mentioned before, it was not something that I took lightly. Again, in my practice, I have never accused or suggested that a hearings official or any other decision-making body was biased. But again, I only had what I had in front of me, which was the hearings official's decision, the last page. And that, if you were to read it from the eyes of the applicant, appeared that the hearings official in this particular case was not able to set aside his personally held feelings. Be that as it may, that's not an issue that I believe that the hearings or that the Planning Commission should concern themselves with, because again, as I said before at the beginning, this body cures any bias that may have been in play. I brought it up simply to suggest that the hearings official's interpretation of policy 2 and the adequate support population interpretation was somewhat clouded by his sympathy for things that were not germane to the C1 zone change. Maybe they're germane in the adjustment review, and maybe they're germane for the diverter, but those have their own process. Last thing that I believe that I'd like to bring up is that the folks that Mr. Sherlock is representing are not, this is not a recognized neighborhood association. The city recognized neighborhood association is the Cal Young Neighborhood Association. I just wanted to clear that up for context. To answer Commissioner Borowski's question, I don't believe that Oakway Sub Area Policy 6 is directly applicable, because that refers to the geo lot to the north, lot 5004, whereas the subject lot is tax lot 100. Thank you. With that, I encourage you to review in detail the memo that I provided to you that goes into greater detail about what I'm talking about, and I'm happy to answer any questions that you have. One thing that I would like Ms. Summers to advise the Planning Commission on is the ability for all parties to respond to information that's been presented today. I understand that the city or that the Planning Commission is having deliberations, or there's a schedule for deliberations for Thursday, but I am just to make it clear, I have not had an opportunity to review any written material that's been submitted, nor would I think Mr. Sherlock probably has not had an opportunity to review the material that I've provided as well. So I don't know how you want to approach that, but I'm willing to engage in that conversation should Ms. Summers feel it's necessary. Again, lastly, I'd like to thank you for your time and for your volunteerism here in the community to make this a great community to live in. Thank you.
So as you know, and as Althea talked about at the beginning of this meeting, the city is under a time constraint to make a decision on this, a final decision on this application. Are you offering on behalf of the applicant to extend that timeline? Is that what I'm hearing? I want a little bit of clarity.
If you give me a moment to confer remotely with my client, I'll get back to you soon.
Okay.
Question for Lauren and Althea. The hearing is still open. I haven't closed the hearing yet. And I see Commissioner Edwards, you have a question. Can I close the hearing and then we can take your question? I don't want to forget to do that, as I have done in the past.
You can close the hearing. I think the hearing portion of the evening is over. I would ask that we wait to close the record until
we hear from
this.
Yeah. Okay, got it. Okay, well, having said that, then I'm going to go ahead and close the hearing. Hearing is now closed.
Chair, I'm sorry. May I respond to Ms. Summers?
Yes.
So that, yeah,
Yes,
I was able to confer with my client, and we prefer that the hearing and the record be closed and that the Planning Commission begin its deliberations.
Okay. Therefore, we can, is it germane to what I'm trying to do, Commissioner Edwards? No, okay. We'll get back to you. So we're going to close the record and the hearing. So the record and the hearing are now closed. Now we can move on to, there's something I should say. The public hearing and record are now closed. Deliberations are scheduled for Thursday, December 17th from noon to 2. And if we do not reach a conclusion on that day, a second meeting is set for Monday, December 21st from 11 to 1. You can watch the deliberations by visiting the Eugene Planning Commission website, where a live broadcast will stream. You can also watch deliberations using the meeting materials and webcasts link from the main City of Eugene website. If you have any questions about viewing the deliberations, please reach out to Althea Sullivan. And now, at long last, commissioners, we have a chance for questions. I see Commissioner Edwards, your hand is up. Take it away.
Thank you, Chair Ramey. I just have a request for Althea. As you're preparing some information, some background information about the adequate support population and the context there, for me, I think what might be helpful is to have a broader understanding of the allowable uses under C1. Are we talking coffee shops or concert venues? Because I think that for me, it would be helpful. And I don't know if that information is supposedly assumed or could be provided as part of, because I know, there's a zoning map, but it's not specified that what are those allowable uses. So for me, I think that would be helpful if that's allowed. And maybe Lauren could tell me if I'm off base here, but I'd like that information if it's possible.
Commissioner Edwards, that there is a use table in the code, which Planning Commission is free to look at, that would show the uses that are allowed in the C1 zone. Or maybe a list of uses, I'm not sure. I'm looking at it, Althea. I will say though that, and we'll talk about this again in deliberations, there are specific approval criteria for a zone change, and the ultimate use of the property is not one of those criteria. So you can certainly have that information, but the commission is looking at the specific zone change criteria, which include, compliance with the metro plan, compliance with applicable refinement plans, et cetera, et cetera.
Follow up to Lauren.
Yes.
For me, what I'm trying to I'm grappling with a bit here is the concept of an adequate support population for what? And if that what is really broad, I think for me that would be hard to quantify. So I guess that's what I'm trying to get at. And I apologize if I'm ahead of myself here, but I think it would be helpful if even you could direct me to that table. I didn't want to poke around and look at anything I shouldn't be, but I would love to see that. So that'd be helpful.
I will briefly respond to that question, Commissioner Edwards. You are more than welcome to poke around in the Eugene Code. I sent a link to that. I believe that was Friday evening that I sent that out. I can look and get you the code citation and we can follow up with that, but it would just be under the commercial uses. I believe it's 9.2 something, and then you would be looking at C1 if you're interested in that.
We have Commissioner Borowski, followed by Commissioner Isaacson.
Thank you. Just a procedural thing, Lauren. And this goes to, I've been in a few more of these type of hearings. As far as closing the record, in the past, that's always been a motion, and the commission makes a decision whether or not to close the record. Normally, is that the procedure that we'll be following tonight, or is it just closed by the authority of the chair? Just procedure. I want to make sure.
Commissioner Borowski, you're right that in the past we have done it by motion. I think it's really up to the chair. If the chair would like to entertain a motion to close the record, we could do that.
Definitely. I'm sorry, Commissioner Borowski. In my experience, it was the chair that did that, but my experience dates back, 20 years ago. So I'm probably not up to speed on these things, and therefore I'm perfectly willing and eager to accept a motion to close the record.
Thank you, Chair. I will make the motion, and I'll just speak to it. Just in this instance, it's not that big of a thing, but there have been quasi-judicial hearings on this when the decision whether or not to keep the record open or closed has been a contentious issue amongst the Planning Commission. And so I just wanted to make sure that we're doing things the same from procedure to procedure to procedure as things go along. So I would make a motion to close the record at this time.
I'll second it.
Moved by Commissioner Borowski, seconded by Commissioner Isaacson. Any discussion? All those in favor, hand where I can see them. 1, 2, 3, 4, 5, 6. Thank you all. Now, where were we? We were back to questions, and we had Commissioner Isaacson in the queue.
Thank you. This actually for all of us, but more specifically because Commissioner Edwards asked, actually on page 264 of the packet that we got today, buried at the bottom of it, it actually talks about the C1 neighborhood. Commercial allows for various types of commercial uses as retails and services, but each business within the new building could only contain up to 5,000 square feet. So therefore, C1 retail could be several restaurants, or several smaller restaurants or retail shops. That gives you a little bit of context there, and if you want to find it, I have it in the text there. I also think that would be great if we could have a little synopsis of the different changes so that we know going into it, for future reference.
Okay, other commissioners, questions for staff, items you'd like to have researched before we deliberate on Thursday? Speed reading courses, perhaps. Okay, good. Well, oh yes, Commissioner Fragola, I'm sorry.
As we're reading through the additional materials that we've received, may we send questions to staff for Thursday, or is that impermissible?
I will let Lauren respond to that one. I'm open to it, but I also don't want to run afoul of any procedural pieces that I may be unaware of.
Thanks. It was a question for Lauren.
Yes, you planning commissioners, you may communicate with staff. There's always the possibility that you ask a question and staff says we can't answer that because the information is not in the record, but communications with staff are not ex parte communications. You are allowed to have communications with staff throughout the decision-making deliberations process.
And I just want to ask one clarifying question. Lauren, would there be any issue if all commissioners were CC'd on an email that came to me?
Thank you for teeing that up for me, Althea. Yes. So as you all are aware, as the Planning Commission, you need to comply with the Oregon Public Meetings Law, which means that when you meet, it needs to be in public. And so email traffic, especially email traffic that includes reply all and could be considered deliberations about a matter that is in front of you, is problematic. So you're free to contact staff directly, but you definitely are discouraged from emailing each other, and especially a quorum of you, so replying all.
Okay, very helpful information to have. Anybody else? Yes.
Commissioner Amy, if I may, one more quick thing. So it sounds like there was a fair amount of information that came in right before and possibly during the hearing. Staff will also need to be reviewing that information and will come back to you at deliberations to let you know whether any of that information constitutes new evidence that needs to be rejected. So there may be some procedural pieces that we have to take care of before you actually enter into your deliberations on Thursday.
Perfect. Commissioner Borowski, I saw your hand up.
Yeah, Lauren just addressed what I was going to say with the volume of the packet that just got delivered at 5:15. The chances are that there might be things in there that are outside the record will need to be addressed at the meeting on Thursday. And sounds like she's going to look into it. Thank you.
Okay, now I'd like to thank you all for attending, and particularly thank you to those citizens who took the time to join us and offer testimony this evening. As many of you pointed out, and as we opened our meeting by saying, we are all volunteers here, citizens of the community, and our work is made better through you and by you. So thank you for all of that effort you took today. And then finally, as a reminder, you can watch the deliberations by visiting the Eugene Planning Commission website, where a live broadcast will stream. And once again, if you have any questions, please reach out to Althea Sullivan, who's our staff on this. So with that, I bid you all good night, good evening. Thank you once again for joining us, and we'll meet again on Thursday. Thank you. See you soon.
Right on time again, hey, Commissioner Ramey. Look at that, 7:28.